The Liberal government announced today a plan to overhaul Canada's federal divorce laws. The goal is to put the best interests of children first. Bill C-78 was tabled today in the House of Commons. It proposes, for example, to drop terms like custody and access in favor of terms like parenting orders and parenting time. But how different will divorce proceedings be if this bill passes? Joining me now from the foyer of the House of Commons is the Minister of Justice, Jody Wilson-Raybould. Hi, Minister. Thanks for being with us.
Thanks for having me.
So 48% of marriages in Canada end in divorce. How will this bill concretely change the way those people experience the process?
Well, as you stated in the introduction, so many people's only interaction with the justice system is through family law, through separation and divorce, and it's very disruptive to the family unit. So there's a number of things that we've done in this legislation, as you said, putting the best interest of the child first. We have put in the proposed legislation a series of factors to be considered in terms of divorce proceedings, parenting orders, or parenting time that a judge can consider or an out-of-court process could consider in determining those orders. We have put in place proposed additions to the Divorce Act, which would focus on preventing family violence, looking at efficiencies and effectiveness of family law, and looking at assisting in reducing poverty among young people, among children.
How specifically are kids, is the experience going to change for kids, I guess, or how will it change the lives of kids whose parents are divorcing?
Well, again, it puts the focus on the kids and their well-being, their emotional well-being, their psychological well-being, their safety and their security. It looks at what the kids actually want in terms of where they would care to reside, what the nature of the parenting order is, if the child has a reasonable ability to relay those desires. It looks at previous factors in terms of history of childcare. It looks, another factor would be around spirituality, cultural upbringing, including Indigenous upbringing. So there's a number of factors that are listed in Bill C-78 that could be taken into account to best determine what the needs of the child are.
When I saw the announcement earlier today, I was wondering why now? It isn't in your mandate letter, and I know you said earlier today in the press conference that it is a personal commitment of yours. So why is that?
Well, I mean, in the press conference earlier, we are focused on ensuring that we expand unified family courts. There's been a commitment in the budget to expand unified family courts. We've done a substantive amount of consultation and engagement and recognize there's been joint committee reports dating back decades that have recommended that we modernize the Divorce Act. I think for everybody in the country, this is divorce and separation and the well-being of children in those circumstances. I think everybody can say they have a personal situation or know somebody that has gone through that. And this is to address difficult situations, recognize that there are young children that are involved, and to alleviate the burdens that children face in these difficult situations by ensuring that the focus is on them, by ensuring that we address issues of family violence and ensuring that the child's support is adequate to provide for that child. And we've introduced various measures to do that, as well as moving away from court processes that can be very adversarial and focusing on out-of-court processes.
Will anything in this bill alleviate the delays that a lot of people experience who are going through family law situations in courts?
I think it will, because
more than putting more money to the problem. Will?
Well, what we've done is to, in Bill C-78, is to inject a lot of information, a lot of considerations, a lot of factors in terms of the best interests of the child, around family violence, around relocation, in terms of if a spouse is leaving and there's a current existing parenting order, which is the most litigated area in family law. It provides factors for consideration. It provides the requirement for actors to advise clients about other out-of-court processes. So there's a lot of things in this piece of legislation that would address delays, that would address the efficiencies and the effectiveness of the family law realities.
Some critics have said that the bill misses the mark because it doesn't include a default assumption that parenting will be shared equally, and in doing so, it favors the mom over the dad. What's your response to that?
Well, I've had the opportunity to hear from many stakeholders, including parenting rights organizations. The focus of this bill, the primary consideration is the best interest of the child. And in terms of moving on this, we haven't put in a presumption of equal parenting because I feel that the best interests of the child are addressed, having regards to the particular circumstances of a case, the reality of the child or children in a situation, and taking into account the factors that we know have been considered by the courts throughout the last number of decades, as well as just the individual circumstances and the realities of the parents that are involved and their necessary responsibilities to provide for their child.